Ready, start. Framing of a charge is an exercise of jurisdiction by the trial court in terms of section 228 of the code, unless the accused is discharged under section 227 of the code, full stop. Under both these provisions, the court is required to consider the record of the case, close, and documents submitted therewith, and after hearing the parties, may either discharge the accused or where it appears to the court and in its opinion there is ground for presuming that the accused has committed an offence, itself frame the charge, full stop. Once the facts and ingredients of the section exists, then the court would be right in presuming that there is ground to proceed against the accused and frame the charge accordingly, full stop. This presumption is not a presumption of law as such, full stop. The satisfaction of the court in relation to the existence of constituents of an offence and the facts leading to that offence is a sine qua non for exercise of such jurisdiction, full stop. It may even be weaker than a prima facie case, full stop. There is a fine distinction between the language of sections 227 and 228 of the code, full stop. Section 227 is the expression of a definite opinion and judgment of the court, while section 228 is tentative, full stop. Thus, to say that at the stage of framing of charge, the court should form an opinion that the accused is certainly guilty of committing an offence, is an approach which is impermissible in terms of section 228 of the code, full stop. It may also be noticed that the revisional jurisdiction exercised by the High Court is in a way final and no intercourt remedy is available in such cases, full stop. Of course, it may be subject to jurisdiction of this court under Article 136 of the Constitution of India, full stop. Normally, a revisional jurisdiction should be exercised on a question of law, full stop. However, when factual appreciation is involved, then it must find place in the class of cases resulting in a perverse finding, full stop. Basically, the power is required to be exercised so that justice is done and there is no abuse of power by the court, full stop. Merely an apprehension or suspicion of the same would not be a sufficient ground for interference in such cases, full stop. At the initial stage of framing of a charge, the court is concerned not with proof but with a strong suspicion that the accused has committed an offence, which, if put to trial, could prove him guilty, full stop. All that the court has to see is that the material on record and the facts would be compatible with the innocence of the accused or not, full stop. The final test of guilt is not to be applied at that stage, full stop. We may refer to the well settled law laid down by this court in state of Bihar versus Ramesh Singh, full stop. Under section 226 of the code, while opening the case for the prosecution, the prosecutor has got to describe the charge against the accused and state by what evidence he proposes to prove the guilt of the accused, full stop. Thereafter comes at the initial stage the duty of the court to consider the record of the case and the documents submitted therewith and to hear the submissions of the accused and the prosecution in that behalf, full stop. The judge has to pass thereafter an order either under section 227 or section 228 of the code, full stop. If single inverted comma the judge considers that there is no sufficient ground for proceeding against the accused, he shall discharge the accused and record his reasons for so doing, single inverted comma close, as enjoined by section 227, full stop. If, on the other hand, single inverted comma, the judge is of opinion that there is ground for presuming that the accused has committed an offence which within bracket B is exclusively triable by the court, he shall frame in writing a charge against the accused, single inverted comma close, as provided in section 228, full stop. Reading the two provisions together in juxtaposition, as they have got to be, it would be clear that at the beginning and the initial stage of the trial, the truth, veracity and effect of the evidence which the prosecutor proposes to adduce are not to be meticulously judged, full stop, nor is any weight to be attached to the probable defense of the accused, full stop.